Albert Einstein. His book and his theories that he came up with, even though economic rights have expired, but his name can never go off. Why? Because it exists in perpetuity forever and ever.
I can tell you that, okay, if I'm going to write this song, I want to retain my moral rights, even though you're going to pay me.
You think that pen drive is now cheap, so you go and buy a pen drive and then you download people's songs onto it, or you go and download somebody's nice picture and you print it, and then you stand under traffic light or you stand at the vantage point and you begin to sell. No, you don't have right to do that.
So as someone who has much knowledge about copyright, what do you think the artists have done? Because artists, for example, medical.
The moment somebody writes a song for you, then it means he owns the name of the writer of the song. This is Bnoskka. We are here again. This is episode number 12, and we are trying to look at the moral rights of an author, the economic rights of an author, and then also an employed author. And basically what we're trying to do is that we want to digest. And so those of you watching us online, please write your comments and tweet about it and picture us and then in your mind, and whatever you think is difficult about it, let us know and we'll be able to answer it for you. And then also we have people in the in-house studio who would also ask them to give us their own their contributions if they do. But before we continue the whole show, this is Bnoskka on IP Zone, and it is brought to you by the Uprise Music Distribution and Publishing Company. Of course, they do it best. So if you have any challenge with your distribution, publications, and all that you think you want to do as far as money is concerned, do consult Uprise and we will surely do it best for you. Let us now hear my guests in the studio, their names and where they have come from. Let me start from my right. Gentlemen, what's your name? And that's your camera.
My name is Samuel Bananjan, a student and then a content creator.
All right, Samuel. Now to my left.
My name is Philip Wang. I'm a content creator. I work at Uprise, and I'm sure you know a lot about me by now.
Of course. So we have Samuel and Philip in the studio today. Right, so basically now let's move on to game. But before we do, I'm telling you, please subscribe, watch, share, click the notification bell, and make sure that you write your comments, okay? And try as much as possible. I don't want you to lose money. You shouldn't be a hit artist before you make money. The very first day you had an idea to start producing your first song, come to Uprise Music. We publish it for you and distribute it to all the digital platforms and give you just one link. When you click, Apple Music, Deezer, Boomplay, Audiomack, all of them are just linked onto one. And you will be making money because as people stream, you would also get the benefit of the sweat you have put in. So as an author, that brings us to the first question. What is an economic right of an author? Now, when we say an economic right of an author, from the Copyright Act that we've been working with all over the world, it tells us that an author is any person or any group of people who have contributed significantly to the creation or the fixation of any copyright work. So for example, a book, two people came together and wrote a book. Then it means the economic right should rest with the two people. Okay, if three musicians decide to make a song and they all contributed together, then it means the economic right that is making money from that work should rest with the three people. So whether it's a movie, the actors involved, the producer, the executive producer, and the script writer, or even the director, all of them becomes an economic right owners. Okay? But then let's look at how does this economic right is defined in the law. It says that the author of any protected copyright work has the exclusive economic rights in respect of the work to do or authorize the doing of any of the following. So the one who has the economic right, he's the one that is supposed to authorize people or commission people to do any of the following: the reproduction of the work in any manner or form, reproduction. Then we have translation, adaptation, arrangement, or any other transformation of the work, whether it's a cover version or rendition or featuring or collaboration. It is the economic rights owner who has the right to do that. Publication of the work or public performance of the work or broadcasting or communication of the work to the public. It is the economic rights owner who has the right to do that. So, for example, if the work will be performed in a public place, whether it's a political rally or it's a school rally or whatever, in the street, in the disco, in churches, in restaurants, pubs, vehicle, aeroplanes, on the radio, on the television, if you want to communicate about the work, that is performing it or publicly playing it or watching it or broadcasting it, it is the economic right owner who has the right to do that. Then the distribution to the public of original or copies of the work by way of first sale or other first transfer of ownership, it is the economic right owner. Here it simply means that once I make a song, who is to sell it? I, the economic right owner. It is not up to anybody. You think that now copyright is free. No, it's not free. Or you think that pen drive is now cheap. So you go and buy a pen drive and then you download people's songs onto it. Or you go and download somebody's nice picture and you print it and then you stand under traffic light or you stand at the vantage point and you begin to sell. No, you don't have right to do that. It is only the economic right owner who can authorize you to be able to do that. Then the last one is that the commercial or rental to the public of originals or copies of the work. It is the economic right owner who can authorize you to commercial it or sell it or rent it to the public. If you don't have the economic right owner's permission, if you do any of these things, you are infringing on copyright, and it's against both criminal and civil. It has both criminal and civil actions that can be worked against you. Now let's look at moral rights of an author. Moral rights of an author basically means that your name, your dignity, your character being associated with the work for the rest of your life and for the rest of the world until eternity. It will never change. Now, if Bnoskka, I make a song, I write a book, I design a logo, I do something, and nobody paid me to work, okay? Then my name, Bnoskka, Bnoskka, should be associated with the work forever. For example, let's take, Albert Einstein. His book and his theories that he came up with, even though economic rights have expired, but his name can never go off. Why? Because it exists in perpetuity forever and ever. Archimedes' principle is a mathematics principle that Archimedes brought. And his name, of course, it's associated with it forever. Anything that you can think of, whoever that invented this microphone, his name will be never forgotten. The cannon, the lights, the invention of telephone, I don't think a day will come that will say Handel's Messiah was never composed by Handel. No, because moral right exists forever. And so therefore, on the moral right aspect, whoever has that moral right, the law says that in addition to the economic rights, which is referred in what we just previously read, the author of a protected copyright work has the sole moral right to do what? To claim authorship of the work, in particular to demand that the name or the pseudonym of the author be mentioned whenever the work is acted or it is performed or it is done in relation to the work, and then also to object to seek relief in connection with any distortion, mutilation, or other modification of the work where that act would be or prejudice to the reputation of the author, or where the work is discredited by the act. So, for example, I make a song and then you use my song, you play it at a concert, you have got my authorization, okay? And then you play it at a concert, and then you go and say, oh, this song was made by Philip. This song was made by Samuel. Oh my goodness. If you don't change and you keep saying this song was made by Philip, this song was made by Samuel, and I know it is my song, I take you to court. You will pay damages for discrediting my work to somebody, because economic right never changes. Even if the person is not alive and he has died, 70 years has come, the work has fallen to public domain, and his relatives hear that you are playing the song and you are mentioning somebody else's name, you, the person making that infringement, you are liable, okay, for not knowing the right thing to do. So that is how moral right works. Now, let's by extension look at mutilation, editing, or trying to change the implication of what the work means. Now, I made a song. The song is about love for humanity. And then you came, you asked me to give you right to use the song for an advert. Okay, of course, I gave you the right and you have paid me. Then I later realized that the song I gave you, the advert you are making, it is actually supporting something. I think that it is spoiling my reputation, my character, my name, okay? And here, name here, in the law we said pseudonym. Pseudonym means the stage name or the artist name. So for example, Bnoskka, Bnoskka is my pseudonym, okay? And my original name as well, Benjamin Odro Ayin Jr. Any of these names, if it is on a work and you choose to use my right to promote something that will spoil my reputation, then the law says that you are infringing on my right. So I can go to court and ask you, please stop making this promotion. I'll give you one example. There was a case that was heard in United Kingdom. It's about 3 guys made a song. Girls, all I want to do is girls. They made that song and they said that they will never allow any company to use that work for commercial purposes. One of the guys died, and in his will, he stated it as well. So the 2 remaining also testified. Then another company came, and then they wanted to promote mathematics, education, and science for girls. They wrote a letter to these guys, please, we want to use your work for this. They said no. The company did not hear. They went ahead to use the song for their advertisement. The guys took them to court. They wrote them a letter. And this company, which is infringing on people, they didn't understand. They think that the people are spoiling their reputation by writing them a letter. So they first went to court to say that these guys are trying to bring us a case against us, and we have every right to use any song for our advert because it's about girls and the song is about girls. The court ruled. Actually, they being the plaintiff, they lost the case because you don't have the right to use a song, whether it is for a good purpose or for a bad purpose, unless the moral right owner permits you to do that. Okay? So, and then also there were another cases where all these LGBTQ plus, QQ, whatever it is, somebody made a song and then they tried to use that song to promote their content. He went to court and he said, look, I don't subscribe to this, so please stop using my work. The court listened and said, don't. Even right here in Ghana, we all know Kojo Fosu, Daddy Lumba. One guy tried to use his songs at programs and all that, and he would mention his name. My name is Anochi Supremo, and I'm doing that, I'm singing it. People said, look, you are singing that Lumba song. When he heard it, he took it to court, and court actually listened and said, Supremo, please don't ever do that again. Okay? And so this is what, by extension, what moral right means. If your name is associated with the work and they are using it wrongly, and if you think it will spoil your reputation, it will spoil your character, you can go to court. This is not fight. You cannot report this at police station. All you need to do is to go to court, because when you do, that is when the law will be able to work on your behalf. And then for economic right, the last one, which is the unemployed author. Employed author here means that you've got creative ideas, okay? And you are editing somebody's video, you are shooting a video, and then by your work, somebody say, okay, I've got a funeral, design this poster for me. The moment you design the poster and the person paid you, you don't have any rights in that poster again. I come to your studio, come and take a picture, and I pay you, you edit the picture nicely, and you give me the copies, and I went away. The moral right is in my hands. Me, that I paid you to take the picture, is in my hands. The economic right is in my hands. Me, that I paid you. But you will be described as an employed author. An employed author here means that your name cannot be associated with the work, and the economic right can also not be granted to you, because I have paid you for your service. This one we call it contract for service. Okay? So once that service has been rendered, your case is finished. I, the owner, now who has brought up the idea, the reason why the law makes it in such a way is that you, the employed author, if I had not come to you and said that, oh, I want you to create this for me, you would have never come up with that idea. That is how the law understands it. For example, if you work, for example, here in Uprise Music, you are a video editor, you are a cameraman, you are a microphone, you are this. All the work you do is an employed author. At the end of the day, if you are paid, you go and the work remains with the company. So if a company wants to publish a book and you design the cover, once you are paid, finish. Even if you are not paid and you say, oh, I just want to design it for you, once you finish designing, you have no right in the work again. Your name cannot be associated. All that we can do is that the cover was designed by Bnoskka. They will write your name in it. If pictures are in the work, whoever took the pictures, his name will be credited. We will say picture by Bnoskka, or picture by Michael, or picture by Grace, or by whoever, or by Max, or by anybody who took that pictures. And before we can incorporate those pictures within the book, we would have also made sure that the one who we are crediting, he is the actual owner of the work. He's the one that has the economic right. So we pay the person, and then because moral right has not changed, we'll put the picture in the book and still mention the person's name in the book that is from this source. Okay? So this is how employed author works. We employ you for a service, and once that service is done, if the work is for you and we are trying to use it, adapt it, we get the right from you, then we can acknowledge you. But if I am paying for you, you sit there, you're a graphic designer, you're a videographer, you are whatever, and I come to your studio, you are a music producer, I come to you, and the contract is that I am paying you for this service. And then we should understand it also this way. An employed author does not contribute significant to a work. Here, what I mean is this. If you go to a music studio and you go and meet a studio engineer, his work as an employed author is this: to open the microphone for you, sing. You open the microphone for the organist to play. Open the microphone for the drummer to play. Open the microphone for the guitarist, all the instruments. If he does that only, and when he finishes, he mixes the work, reinforces the sound or master it, and then he gives you the finished product, he has finished his work. But the moment he sits behind the keyboard, and he plays the keyboard, and he works, he has become an author of the work. So economic right will now come in here. He has moved from an employed author and he's become an economic right owner. Okay? So his name will be associated with it. That is how, by extension, employed author works. If the person contributes significantly, then you would know that by extension, this is what your benefit. Now, let's take, for example, you want to design an Uprise music app that when people sit in their home, they can just log onto the system and register to do their publication, upload their songs, and do their distribution. And then there's the director. He call you, Mr. Michael. He calls you and say, oh, I want you to design this soft code for me. I want you to, the code should do this. The software should do that. It should do this. And you, the software designer, you sit and you use all your ideas and you finish. When you finish, that app you have created belongs to the director who called you to come and work for him. He pays you and you are off, you go. You don't have any economic right. You don't have any moral right in it. The moral right belongs to Michael, the one who called you, and the economic right belongs to him. You are only an employed author, so your services end there. Now, let me come back to the studio and see what my guests have got for me. I'm sure you want to go to the first question, so do.
Okay, so with regards to an employed author,
Yes.
one thing I know is that the employer obviously gets to enjoy economic rights.
Yep.
But when it comes to moral rights, I think then there's a bit of an agreement that has to go through. Because when it comes to moral rights, even though you've been employed as an author, unless you waive away your moral rights, you can retain your moral rights and let the employer know that even though you're employing me, I'm still maintaining my moral rights.
Okay, so by moral rights, how do you know? I want to know.
Okay, so
We don't deal with what everybody knows, else everybody will know everything.
yes, so
How do you know?
so from your explanation, the economic right, I'm going to start with the economic rights. It's the right to earn from your work. And the moral rights is the right to associate your name
With a work.
likeness to a work.
Yeah.
So if, let's say, I'm a writer and you come to me that, okay, you want me to write a song for you. You give me an idea and I write it. I can tell you that, okay, if I'm going to write this song, I want to retain my moral rights, even though you're going to pay me, right? If we don't explicitly discuss it and you go ahead and you produce the work and you later say that, let's say it's Samuel who did the work, I can challenge you in court.
Good. So here you are saying that explicitly declaring. So this is what the law says. It says, in the absence of any contract to the contrary, the economic rights of a work shall vest in the employer.
Yes, that's
Good.
the economic, not the moral.
Hold on. Any person who commissions the work when the employed or commission author has created the work in the course of the employment of the commission, the moral right shall rest in the employer.
Okay. Okay, wait. So you see, this is
Can I explain?
sure, please.
Okay, good. So if you are being employed and then in your contract of service or contract for a service, you see that whatever I create here, I want my name to be associated with it. And the employer agrees to that. Then your name will be associated with it. Okay? If the employer says no, it will not stand. Then you better don't do the work. Just go.
Yeah.
Okay? Go. But if the employer agrees, then your name can be associated. Because the moment you create a work, your name would not just stand like that. It must be based on a contract and that must be enforced. That is when you can use the law. This is Section 7 of the Copyright Act. You can now use it to work your case against. Let me hear somebody else too. Yes, in-house.
Okay, so say at the latter ending of 2023,
Yeah.
I saw the emerging, or we witnessed the emerging of a group of people who call themselves lookalikes. And these people perform songs of our mainstream artists on like bigger stages.
Yeah.
Not even, apart from just performing their songs, they also had the brand images of our artists.
Yeah.
And then in a few weeks, we saw a back and forth argument between the lookalikes and then our artists.
Yeah.
So as someone who has much knowledge about copyright, what do you think the artists have done? Because artists, for example, medical.
Okay. Yeah. So this one, let me just make it quickly and short. There's another law which explains this into details. We call it Act 589. The name is called Protection Against Unfair Competition. And Section 2 talks about misleading the public. And Section 3 talks about causing confusion in the minds of the public. So here, lookalike would then feature into that aspect of the law, whereby the person who looks like somebody, if he doesn't venture on the product, if he doesn't venture on the service, if it does not begin to sing like the person, like the example I gave you about Anoche Supremo and that Iluma case. If that comes into play, then you are infringing on the right. Okay? But if it doesn't come to play, in fact, all over the world, there's a research that was done and it is titled Celebrity Worship Syndrome. You can read that article. It's available on the internet, Celebrity Worship Syndrome. People all over the world try to look like an artist, For example, Michael Jackson, somebody will wear a shirt, put a band here, wear hand gloves, white, and then begin to dance like a Michael Jackson, blah, blah, all those things. The moment you begin to commercialize that activity, then you are competing unprofessionally. Okay, so that law, another time, we'll take you to look at. But today, let's look at employed, moral, and economic rights of an author. Yes, Megs.
Yeah,
Let me
we
hear
know that.
you. Go.
My question has to do with songwriting.
Okay.
So if I employ somebody to be a songwriter, let's say at my record label,
Yeah.
and I choose to give the person the moral rights of writing his name as part of those created person,
Okay.
I can just say, oh, with my contract, I don't want the idea behind the song, the person who
revealed.
wrote it to be
No,
revealed.
that is not possible. The moment somebody writes a song for you, then it means he owns the name of the writer of the song. Okay?
So he has the moral.
He has the moral right, but the economic right will go into a contract agreement aspect. Okay? So, for example, I write a song for you, or you ask me to write a song for you.
Yeah.
You did not tell me what to do. I sat down and wrote everything A to Z. And I said, okay, sing it this way, sing it that way. I am the writer. So the contract will say that, okay, then I have 50%, you have 50%. Oh, or take everything. But anywhere you start to perform, after you perform it, you have to say that the song was written by this person.
Okay.
Yeah. And that should not change forever.
Yeah.
Yeah. So you become a performer. So when we get to another portion, another section of the law, I will explain what a performance fee is and an appearance fee is in terms of performance.
Right.
All right. Any more questions?
So, has there ever been an instance where an artist has sing the services of maybe, let's say, a songwriter, and then the contract was the songwriter should write a song from A to Z,
Yeah.
and then the songwriter wasn't able to write to that particular duration, but to, let's say, F.
Okay.
So, and then the duration, like the time to release the song was like,
It was due.
yeah. And then so the artist came for like A to F,
and
then it took away. Is it necessary for the artist to still credit what the songwriter has done?
Of course. If that A to F was not done, how would you have completed it? So the law will say that significant contribution. For example, you have your song, and I do it most of the time. I listen to your song, and the title you have there, it says expert. And then I think that the song should be named karaoke. If I give you that term, karaoke, and to change it, I have done nothing. Okay? That one, I don't have any right in it. It is insignificant. If whether I had changed the title or I did not change the title, the song will still go. Or if I change one word in it, oh, don't sing it minyankopon, sing it minyankopon. Okay? Or don't sing it I love you, say I cherish you. If I do that, I don't have any right. My contribution is insignificant, so I don't have any right in it. Okay. So we are looking at significant contribution. And like you said, your contract was to do A to Z, and you were not able to do A to Z, but you did A to F. So whatever you've done, if it's a significant contribution, the law court would listen to you and see if you deserve. There was a case where 3 people decided to write a book. I've forgotten the case title. And then the first day they met to share the ideas, they all came up with idea, you, this. Then the next time they were supposed to meet, one person involved in an accident, and he stayed in the hospital for 6 months. One person sat down and wrote the book and gave it to the second person to edit. He edited it and changed chapter and added 2 chapters to the book. And then the one who was at the hospital came back and did editing of the book A to Z. Then when the work came out, his name was not inside. He went to court, and the court said yes, whether he had edited it or not, the book would have still come out. Your contribution was insignificant. Okay? So that then it now presupposes that if I give you my work, oh, Charlie, read over my work for me and edit it for me, it doesn't automatically make you an author in my work because your contribution was insignificant.
But at least the person contributed.
It contributed good A to the work. So here I would wish we move it to the court because we need some of these cases as test cases. your argument is your opinion. Somebody's argument is also opinion, so that we can have both sides to argue to see where the thin line should lie. Any other question so that I wrap up quickly? Yes, Philip.
Okay, so for most people out there who
Under 10 seconds.
who have who create works and they have the economic and the moral right,
Yeah.
can they decide to sell these rights separately?
Good. We will look at that in the next episode. We call it the transfer of copyright. So we will look at that into details. In the absence of that, this is Bnoskka IP Zone, brought to you by Price Music. We do publishing and distribution. Make sure you use our services and make sure you subscribe to this video, like it and share. And of course, it is good to be with Price Music. This is Bnoskka, I'm telling you. We meet again.